Welcome to Vishnu Consultants. Today we will discuss about Hindu family law in brief. What are the primary sources of Hindu law? There are four primary sources of Hindu law which are as follows. Shrutis, which is Vedas, Smritis, digest and commentaries, and customs. What are the secondary sources of Hindu law? The secondary sources are judicial decisions, legislations, equity, justice, and good conscience. Now, what is a valid custom? Below are the points which are very essential for a valid custom. It has to be ancient, invariable and continuity, reasonableness, clarity and unambiguity, not opposed to morality or public policy, not opposed to express provisions of law, onus, judicial notice of a custom. Who is a Hindu? A Hindu is a person who believes in the religion called Hinduism, or any person who is born of Hindu parents, that is, parents who are Hindus, Jains, Buddhists, or Sikh. Any person who is not a Muslim, Christian, Parsi, or Jew, and who is not governed by any other law practicing it or by professing it as a Hindu. Now, who is not a Hindu? An illegitimate child whose father is a Hindu and mother is Christian, and the child is brought up as a Christian, or also the illegitimate child of a Hindu father and a Mohammedan mother, because these children are not Hindus either by religion or birth. Children born to Hindus who are later converted to Muslims, Christian, Parsi, or Jews. Third is children born to Hindus who don't follow the principles of Shastra. Now let us understand what is a Mitakshara school. Mitakshara is one of the most important schools of Hindu law. It is a running commentary of Smriti written by Yajnavalkya. The school is applicable in the whole part of India excepting West Bengal and Assam. The Mitakshara has a very wide jurisdiction. However, different parts of the country practice law differently because of the different customary rules followed by them. Mitakshara is further divided into 5 sub-schools, namely Banaras Hindu School, Mithila Law School, Maharashtra Law School, Punjab Law School, Dravida or Madras Law School. All these law schools come under the ambit of Mitakshara Law School. They enjoy the same fundamental principles but differ in certain circumstances. What is Dayabhaga School? Dayabhaga School predominantly prevailed in Assam and West Bengal. This is also one of the most important schools of Hindu law. It is considered to be digest for the leading Smritis. Its primary focus was to deal with partition, inheritance, and joint family. Dayabhaga School was formulated with a view to eradicating all other absurd and artificial principles of inheritance. The immediate benefit of this new digest is that it tends to remove all the shortcomings and limitations of the previously established principles and inclusion of many Cognates in the list of heirs, which was restricted by Mitakshara School. In Dayabhaga School, various other commentaries were followed. Look at the following. What is a joint family? A Hindu joint family consists of lineal descendants of common ancestor. In other words, a male head and his descendants, including their wives or unmarried daughters. What is coparcenary property? A coparcenary is a small unit of the family that jointly owns property. A coparcenary consists of a propositus, that is, a person at the top of a line of descendant, and his 3 lineal descendants, sons, grandsons, and great-grandsons. Coparcenary property is named thus because of the ownership is marked by unity of possession, title, and interest. The head of the Hindu joint family is called the Karta, or the manager of the joint Hindu family. He occupies a unique position in the family. The senior most main member of the Hindu joint family is usually the Karta, or the head of the family. Karta's power of management is absolute. No one can question the duties of the Karta, like he can manage or mismanage the property, family, business any way he likes. Karta cannot deny the maintenance and occupation of property to any member. Karta is not liable for the positive failures. Here are the following rights of Karta. Karta of a joint Hindu family has some liabilities as well, like the liability to maintain, liability of render accounts, liability of recovery of debts due to the family, liability to spend reasonably, liability not to eliminate coparcenary property, liability not to start new business, and so on. Under the Hindu law, a son is under pious obligation to discharge his father's debt out of his ancestral property. Marriages can be classified into three types, such as monogamy, polygamy, and endogamy, or group marriages. Marriage between two Hindus will be solemnized if the following conditions are fulfilled. Let us understand the ceremonies of Hindu marriage. Hindu marriages are solemnized according to the customary rites and ceremonies of either of the couple's custom. One of the rites and ceremonies include the Saptapadi, where the bridegroom and the bride take 7 steps before the sacred fire. The marriage is bound and completed when the 7th step is taken. As a proof for Hindu marriages, the government has implemented rules that provide the particulars relating to their marriage and conditions that are prescribed in the Hindu marriage register. The government provides that entering of the particulars would be compulsory in the state for some cases as per the direction that has been issued. However, violating this would lead the individual to pay a fine. The Hindu marriage register is to be opened for inspection at reasonable times and will be considered as evidence of statements. This is given by the registrar on payment of the prescribed fee. The validity of the Hindu marriage will in no way be affected by the omission to make the entry. Now let's look at the trends in the institution of marriage. Indian society has been witnessing a number of changes in the institution of marriage, like changes in the ritual of marriage, exogamous marriage, increase in the age of marriage, dowry system, dissolution of marriage, widow remarriage, and so on. Restitution of conjugal marriage. Marriage under Hindu law is considered to be a sacred bond. To protect such bond in case of insignificant misunderstandings is the main object of the law, and to help in maintaining sound conjugal life. This concept comes into place when one of the spouses denies any of the marital rights to the other spouse. For instance, if a husband denies his wife to stay with him under the same roof, it's a violation of conjugal rights. According to law, when either husband or wife withdraws from society of the other, the aggrieved party may apply to the court for a direction that the other party should live with him or her. Section 9 of the Hindu Marriage Act. Such a petition is to be filed before the district judge. What is void marriage? A marriage is considered void under the Hindu Marriage Act if it does not fulfill the following conditions of Section 5 of the Hindu Marriage. If any of the parties have another spouse living at the time of marriage, it shall be considered as null and void. If the parties are within a prohibited relationship, unless the custom allows it, a marriage between the parties who are sublinguals, or in other words, a marriage between the parties who are of his or her relations or of the same family. Avoidable marriage is basically a legal marriage, which can be cancelled by any one of the parties to the marriage and is contested in the ground of the basis of the following mentioned grounds. Section 10 of the Hindu Marriage Act 1955 provides a judicial separation for both the spouse, those who are married under the Hindu Marriage Act 1955. They can claim the relief of judicial separation by filing a petition. Once the order is passed, they are not bound to have cohabitation. Judicial separation is a medium under the law to give some time for self-analysis to both the parties of disturbed married life. Law gives a chance to both the husband and wife to rethink about the extension of the relationship, while at the same time guiding them to live separately. By doing this, the law allows them the free space and independence to think about their future path, and it is the last option available to both the spouses for the legal breakup of the marriage. Divorce is a serious issue and must be used only as the last resort. In the Hindu Marriage Act, there are some provisions given regarding a valid divorce. That is, when the spouse can get divorced or appeal for dissolution of marriage in the court of law. For the interest of the society, the marriage or the marital relationship needs to be surrounded by every safeguard for the cause specified by law. Divorce is permitted only for a grave reason, otherwise given other alternative. The Hindu Marriage Act is based on the fault theory in which any one of the aggrieved spouse can approach the court of law and seek the remedy of divorce. Section 13 Clause 2 provides the ground on which only the wife can approach the court of law and seek the remedy for divorce. Section 13B of the Hindu Marriage Act 1955 provides the provision for divorce by mutual consent. It explains that if the parties that are living separately continuously for a period of 1 year and the parties are not able to live together and have agreed to separate mutually, then they can seek divorce by mutual consent. Divorce by mutual consent is the best way of divorce, as the parties do not have to badmouth each other in the courtroom and both parties can mutually settle on all issues and end their marriage. provisions of Pendente lite in Hindu law is in Section 24 of the Hindu Marriage Act 1955. The court is empowered to grant two specific reliefs to the husband or wife as Pendente lite when the matrimonial suit is pending as per the section they are. The Act has no description of the word adoption per se, but it is a Hindu law derived from uncodified Hindu laws of Dharmashastra, specifically Manusmriti. The right of maintenance arises from the concept of an undivided family. The head of such family is bound to maintain its members, their wives, and their children. Hindu Succession Act prescribes the rules relating to succession applicable to Hindus, Sikhs, Buddhists, and Jains. It extends to majority of the Indians. Next is the Sharia law, which is applicable to Muslims. Then in the Indian Succession Act, which applies to Christians and other persons not covered by Hindu Succession Act and the Sharia law. In a dynamic and diverse country like India, succession is a very tactful issue. It may either be testamentary succession, one with a will, or intestate succession, one without a will. A will is basically a declaration expressing the desires of the person with regard to his estate and provides for its transfer upon his death. In the joint family consists of lineal descendants of a common ancestor. In other words, a male head and his descendants, including their wives and unmarried daughters. A coparcenary is a small unit of the family that jointly owns property. A coparcenary consists of the propositors, that is, a person at the top of a line of descendant, and his three lineal descendants, son, grandson, and great-grandsons. Coparcenary property is named thus because the co-ownership is marked by unity of possession, title, and interest. For more such educational content, subscribe to Vishnu Consultants.